Good morning once again, and I would like to welcome you again to this class. In this second section of the course, that is Legal Methods 2, we will continue with topics under this section. You will recall when we started, we looked at the application of legal materials and we dealt with what legal research is all about. Thereafter, we consider the type of legal research we have, why legal research, and how research can be conducted. And also, we took the journey further by looking at the library, looked at the role of the library, the role of the librarian, how books are identified in the library. Then we also look at the various classification system that we have. Also, we look at the process or procedure for tracing a particular book in the library. So also we examined the library catalog, so electronic uh, card as it relates to the usage of the law library. And then we took on another topic with which is known as statutes. We look at statutes, and then we consider the various types of statutes that we have. And we mentioned federal statutes. We gave examples of federal statutes. We also look at states. We examine some examples to drive home the point. So also we saw local government aspect of it, and then the subsidiary legislation. So with that, we will now move forward to look at another topic which is already before us this morning, law reporting, or what can also be called case reporting. Okay, so it's also a practical class, but it's important that we, look at the theoretical aspect of it before we expect that you go to the field to uh, take a test of what is being taught. Okay, so that is what we have before us in this class. So the first question we need to ask ourselves is the question: what is a law report? That's the first question we're going to be looking at. And from the slide, a law report is a record of judicial decision on a point of law which sets as a precedent. By now, you must have been taught or you know so much about the doctrine of judicial precedent, which is also known as stare decisis or case law, as the case may be. So, without actual reporting, that is taking judicial record of decisions on points before the court, the doctrine, the actual practice of the doctrine of stare decisis or judicial precedent will become practically impossible. So, to make the doctrine functional, there must be decisive acts of law reporting. And that's why we define law report as a record of judicial decision on a point of law, which sets as a precedent. And usually, law report is an essential component of the court of records in Nigeria. And by being court of records, this is one of the fact that they document their activities, their proceedings, gave the court the status of court of record. And then taking it further, we need to know that not all decisions taken in a court of law set a precedent, however interesting they may be in terms of the fact of the case or its consequences. So, meaning that when there are cases before the courts, some decisions, even though they are part of the proceedings, don't serve as precedents, but they still form part and parcel of the case. And before maybe your mind will want to go to the concept of ratio decidendi and obiter dictum. Like we've said earlier, simply put, ratio decidendi talked about the reason for the decision, that is, or the principles of law upon which the decision of an honorable court is based on or is arrived at. So, a decision is only reportable if it lays down a new principle of law or changes or clarifies the existing law. So, the purpose of law reporting, which you may not find on the pages of this slide, is to aid the development of our laws. And that's why, even though it has been established over time that the judiciary does not have the powers to make law or does not manifest the function of lawmaking, but you discover that it is the actual workings of the court that determines valid laws or laws that are applicable or laws that can further mold the judicial system of any country. It is sufficient for the legislature to put out the law, its application, its interpretation, and achieving the purpose of the same law, the said law, relies heavily on the court system. So, therefore, when cases are before the court, being a court of justice, seeks to listen or accept submissions from parties. And in these submissions, oftentimes, there are new developments, new principles of law, and can even be a discovery that took place in the course of hearing the case. If you look at the case of when the neighborhood principle was was arrived at. The case before the court was not the neighborhood principle, but it was a case of, oh, I've been injured by your act. I've been injured by your negligence. I've been injured by the failure of you to uphold the duty of care you have towards me. And that led to the question, who is my neighbor in law? Because if you have put out a product and then the product has caused an harm, even to people you do not know exist, but by virtue of the fact that they consume the said item, they become a direct part of the chain which you have set in motion by preparing or producing the said item. So anybody who comes in contact with your product is your neighbor. And that's why the court summarily came up with the neighborhood principle to the effect that anyone that is harmed by your action is your neighbor. So at every point in time when cases like that come up, they help to lay new principles of law. Now, look at how beautiful that principle is, that to anyone you come across who is likely to suffer or to have him to be impacted by your action is your neighbor. And if you have to reason it out properly, there's hardly anyone who may want to object to that principle or that submission. And that's because it carries in it a lot of truth. Apart from truth, it also comes under logic or proper reasoning. That anyone who comes in contact, who becomes an object of your action, can be tagged as your neighbor. So law reports or reporting helps to document such new principles for the development of our jurisprudence. And then sometimes there are changes as the society changes, the law also may change. Depending on the needs of the society, the existing law may be interpreted to achieve the intention of the legislature, thereby presenting like a modification of the law that has been made. So that's what, one of the things you need to note about what law reports is all about. Now, it's important while we're looking at all of this to look at how did this law reporting start? What is the history behind it? Before I delve into that, I noticed someone raised the hand, probably to ask a question or to contribute to what we are saying. Is the person still on the floor? Hello? Okay, all right, let's move on then. We're looking at the history of law reporting. Case reporting plays a critical role in legal education, as well as legal research and judicial precedent. I've said that earlier, that without the actual reporting of cases, the doctrine of stare decisis may just be on paper without actually fulfilling its purpose. So case reporting refers to the process of recording, publishing, and disseminating the judgment of court for use by students, legal practitioners, even judges themselves, and scholars who participate in the propagation of legal education. So, case reporting, brings about that positive impact on all the people that we have listed. And the history of case reporting in Nigeria is closely tied to the development of the country's legal system and legal education. And then that's why, again, we may have to look at where we were before, the history of our legal system, how we developed, what influenced our development, and some of the things we have in our system, how did they come about? All of that, are issues to be considered under this. But as it will be practically impossible to talk about the Nigerian legal system without talking about our colonial heritage, it will be practically difficult to judiciously deal with any topic, and then that will not be considered. So let's move further in on this. So case reporting or cases constitute an important part of the common law legal system. Why? Because they are regarded as an important source of law in common law jurisdiction. And of course, that also speaks of the history and the foundation or the beginning of the subject matter of discourse. And of course, usually, like we know that cases will usually involve argument by opposing sides and a decision by a judge who is regarded as an independent umpire. Many things that are open to litigant A may not be open to litigant B. And the judge who serves as an umpire there may see it. Look at the case I spoke about that brought about the issue of neighborhood principle. The defendants, we hardly know that anybody that is affected by my action constitutes uh, my neighbor. So, and with that case, at least we are able to understand better by the reasoning of the judge that, oh, it is not the man that lives next to you that is your neighbor alone, but anyone who may be affected by your actions. So let's look at the history properly. But of course, we know that this subject has very great link with the common law jurisdiction. So the history, we include the pre-independence era that talks about the colonial era. We also that will also touch on our colonial influence and the usual unofficial and irregular reports. We'll talk about number two, which is post-independent era, and then how we got to where we are. But I think we should just take them, one after the other. Let's look at the first one, which is the pre-independence era. That's before 1960. talking about colonial influence, we said earlier that Nigeria inherited the English common law tradition due to our colonial relationship. And in early colonial times, decisions from English court and British West African colonies, talk about Ghana, Sierra Leone, were referred to in Nigeria. So there was little to no formal case reporting of Nigeria court decisions. But you can be rest assured that all of those cases that were being cited or picked from the decision of court in England and also in some West African colonies became part of what were deployed in the country, prior to that time. And there was, like I said, there was little or no formal reporting here. So one of the early efforts were in what we call the unofficial and irregular reports. So we know that some early court decisions were reported informally by colonial administrators or legal officers, but there was no standardized or systemic or what we call systematic method for publishing judicial decisions from Nigeria. But of course, there were documentation, so to speak, that does not in any way or so many ways align with the standard that is expected of a law report. But again, this was our early stage. And then it was the beginning of our own development. Class, are you with me? Can you hear me?
Yes, sir.
Okay.
Yes, sir.
Okay, thank you for the information. So for number 2, which is the post-independence era, which we are classified between 1960 to 1970s, there were establishment of Nigerian law reports, also legal education development, and then we have the influence of the Nigerian Legal Aid Council, meaning that as at this stage, we have moved from the unofficial and irregular reports to the establishment of the Nigerian law reports. Also, the legal education has also developed, and which also further aid the development of that time. And it's also important to know that it was around this time when this Nigerian law report was established that we began to publish the decisions of the Supreme Court and other superior courts. And it's important to note that this point was more or less a turning point in formal and organized case reporting in Nigeria, because a lot of expertise and and the plan or decision to standardize the procedure eventually, led to the system growing from the unofficial and irregular report to a more standardized and systematic law report from Nigerian courts. And then when we talk about the legal education, as at that time in 1962, the legal Nigerian law school came into effect, same also with the faculty of law in universities such as the University of First Choice, University of Lagos, University of Ife, which is now known as Obafemi Awolowo University, and then law students began studying Nigerian cases rather than relying solely on foreign cases. The establishment or development that came with legal education in Nigeria brought one way or the other, there is the patriotic spirit that tends to come or follow the fact that we have a court system. No matter how organized or how the court system is, we too can begin to develop our own system. So that led to uh, the students at that time also studying and exploring Nigerian cases rather than relying on foreign cases. And then when we talk about the influence of the Nigerian Legal Aid Council, this institution and others promoted access to case law and contributed indirectly to the spread of law report for educational use. And of course, when so much noise began to come up, there was this concentration to see also how our own system can develop as a growing nation or as a growing people as at that time. So we look at number 3 under this history. We talk about the expansion and diversification that happened or took place between 1980 to the year 2000. And that led to what we can refer to as the introduction of multiple law reports, uh, as well as several private publishers came on board, and then they began to produce law reports with more regularity and variety. And of course, because of the number of people who have come in there, a case of monopoly or low growth became absent. Because with the players who are now engaged in law reports, it brought about, some varieties of law reports, and aside that, it came with it it brought some level of standardization and regularity to the available law reports that were in place at that time. Of course, we can say that because of the existence of healthy competition, many of those who began to participate in the law report system had to do more in order to have their own system, their own report as a more preferred report for either the Nigerian students, judges, and legal practitioners alike. We have examples of these law reports to include the Nigerian Weekly Law Report. This started in 1985, and it's widely used today in a judicial system and for educational purposes. We also have the Federation Weekly Law Report, FWLR. We also have the All Nigerian Law Reports, we have the commercial law report, we have the Supreme Court report. All of these are law reports into in a period that we refer to as the expansion and diversification period. Okay, then with the arrival of technology in full force, it led to the age of digital age and modern development, which we can classify in between the year 2010 to the present time. Of course, what will happen tomorrow will be added to this list. Probably another phase will come that is after the digital age. Surely it will come, but the digital age that we refer to here uh, is part of the history of the development of law reports in Nigeria. So, for example, I return back to that number three to say that law report then became an integral teaching method, judicial reasoning and precedents. That's one of the things that the expansion and diversification era brought. And then universities had to incorporate case analysis and case citation as a major part of their curriculum. I remember then also when we are asked to go to the library to brief a case, which of course, because of digitalization and the age of technological advancement that we are in, I'm not sure anybody would have asked you to do that. But for the purpose of this class, we have to embark on on this, and of course that will also aid your understanding and also your participation in assignments and research work and also moot court participations. Okay, so all of that came under the expansion era. So now I'll go back to item 4, which is digital age and modern development. And that brings to us digital case reporting. Okay? Digital case reporting. Before, what take an individual in identifying whether they are in law firm or not, it is the number of the law report that appear. Like I told someone, I said very soon you will probably not be able to find one hard copy of a legal report in our law firms or even in the university library, because now the raw report booklet and every hardcover materials are now just a click away on our phones. Okay? And to make matter become more interesting, we now have various platforms that have engaged, embraced, and also maximized the digital law report platform or era. We have the likes of the Law Pavilion, we have the Legapedia, and then even the judgment of the Supreme Court online have also revolutionized access to Nigeria case law. All you need to do when you want to deploy all of these resources is to know what you want. And the digital platform will assist in bringing out the cases you need within a twinkle of an eye. So law students and law lecturers now have digital libraries and can conduct real-time research, legal research, using the what we call the electronic databases. And of course, this is a welcome development because of the fact that it saves more time and then energy, even resources. And then, as at this time now, it has now been fashioned into some academic curriculum. Like legal education in Nigeria has evolved to include the use of the digital case law tools. And this has continued to stay and will continue to shape the law report system in Nigeria. And number 5, challenges in case reporting and legal education. What are the challenges? Now, delay in publication is one. Some law report public judgment months or even years after delivery. This is with countries who will probably or outfits who will probably make available a sort of report as arrival in like 5 minutes ago, it becomes one that has gone viral. This is a possibility because of the fact that digital case citation has made that possible. So the challenges is one, the daily publication, which can only happen or when the actual publication can only happen when there are no delays to the uh, process. So inconsistency in citation styles is also another challenge because we cannot point to any single uniform citation format that is enforced. This causes confusion for students. Another challenges this you can mention is access and the cost. Commercial law report can be expensive, limiting access for students in understanding or universities that are underfunded. Okay, then another challenge, coverage. So reports focus on
No, people were voting from outside. This
over
couple.
court decision. Okay,
And you know they
some
don't return
focus
exclusive
on
that night.
the
They
Supreme
don't
Court judgment.
exclusive that night. They closed up that night.
Esther Obala.
They don't want to explain anybody again.
Esther Obala, you are disturbing this class. That's your last warning. Ngozi Esiago, you raising your hand? You have the floor, please.
Yes, yes, sir. Good morning, sir. Sir, we can't really hear you because the network is going and coming. Your voice, so we are missing some things. And I want to ask a question.
What do you suggest we do to the network before you ask your question?
I don't know.
Can we tie it down? Okay.
No. I want to ask a question. Sir. Hello? Mm.
My network that is misbehaving. All right, let's move on. Maybe when Ngozi is back, we can have her.
Yes, I'm back. Sir, you talked about a case whereby the employment about it's because of a neighborhood that it shows a neighbor. So what case is that, sir?
I didn't get you where.
Of the class, sir. We're talking about something that caused neighborhood, like the goods that the person consumed. It has formed like a neighbor. So what case is that, sir? If you can go and make more research.
Okay, I think it's Donogu versus Stevenson. Yes, that's Donogu versus Stevenson. It's one of the foreign cases that was reported in 1932. Okay,
Yes, sir.
Donogu.
Thank
I'll
you.
spell it for you. Donoghue versus Stevenson. Stevenson. Okay. The
Yes, sir.
fact of the case is that, are you with me?
I'm with you.
Yeah, for the entire class also. The fact of the case is that Mrs. Donogu consumed a bottle of ginger beer bought for her by a friend. The bottle contained the decomposed remains of a snail, which led to her falling ill. She sued the manufacturer, that's Mr. Stevenson, for negligence. Okay, that was the fact of the case. And Lord Acton submitted in the course of that judgment that everyone must take reasonable care to avoid acts of omission which can reasonably foresee or would be likely to injure your neighbor. And went further to say, who then is your neighbor or my neighbor? And the answer was that any person who was so closely and directly affected by my act that I ought reasonably to have them in mind as being so affected when I'm directing my mind to the act or omission which are called in question. So as I earlier explained, anyone who is affected by an action is one who is your neighbor. So you can take more time to study that out properly. Are we okay?
Yes, sir. Thank you,
All right.
sir.
Thank you. So we look at number 6 now. The relevance of law report to legal education. Now, case reporting supports understanding precedent and stare decisis. Now, if we take the submission of court in the case of Donogu versus Stevenson that I just briefly gave you the fact and how the neighborhood principle came into place. You notice that the case of Donogu and Stevenson now helps us as at today in this class to understand how the judicial precedent works or how the doctrine of stare decisis works. So, number one relevance is that it supports understanding precedent and stare decisis, and it also aids what we call critical thinking and legal reasoning. Okay, that's number two. It supports critical thinking and legal reasoning. It also aids in moot court competitions, okay, so that you can have sufficient authorities to dismantle the case of your opponent. And then relevant or the relevance to legal education is that writing skills. Because as you grow in it, you understand better and better in the course, of your engagements. So on this, the issue of case reporting in Nigeria mirrors the development of the Nigerian legal system and education, because from its colonial route through post-independence reform and modern digital transformation. So case reporting has become a foundational tool you are doing today. And again, it enhances legal research, support doctrinal analysis, and bridge the gaps between law in books and law in action. Okay? With those powerful reasonings and ratios, it can only help law students understand law as it is in the book and also in the real sense of things. Okay? So that's for that. We now move forward to look at the features of a law report. Okay? For those that can see my slide, um, these are the features. You see that cases are usually recorded in law report. We have examples as it relates to Nigerian law report and all of that. The thing is that the report usually lay out important aspects of the case, such as the facts, the issues, and the verdicts, which is usually the outcome of the legal exercise or of litigation. So one of the major features is that it brings out the facts, the issues, and the judgment. And of course, like you know, that the judgment of the court is usually by judges. Now, if you would look at the slide, you see case structure and reasoning. And the first part of it is to distill the material facts. What are the material facts? Class, let somebody speak to me now so that we know that we are together on this. What do you mean by material facts?
The fact of the case, sir.
The actual incident of the case.
The what?
Actual incidents or circumstance of the case.
Okay. So they need to talk about that because when you look at the brief fact I give to you about Stevenson, it's the actual permit me to use the word story, or which are the transaction within the case. Cannot refer to as the fact or the material fact. And then when that one is done, you will notice that issues will be raised, which is to determine the legal issues arising from the facts that has been laid down. For instance, if there is an allegation of murder, and then a story is told of how Mr. Ade gained unauthorized access to Mr. Sunday's apartment and made attempt to dispossess Mr. Sunday's Mr. Sunday of his belongings. And Mr. Sunday felt, no, this cannot happen while my eyes are open. And then a struggle ensued. Before you know, Mr. Sunday was killed by the intruder. That is a fact. And what follows is that what are the issues surrounding this? Because the issues surrounding them, they are the major focus of the court of law. And when these issues must have been put forward, there will be need for the court to determine one way or the other. I'm sure you must have also learned how issues are couched or what is an issue. Can anybody help us and probably share an example with us? Hello?
Good morning, sir.
Is anybody with us on this?
Good morning, sir.
Yeah, morning.
Yes, sir. I would say that an issue is like a question for legal determination.
Hello?
So, for example, can you hear me, sir?
Yeah, your voice is cracking. I'm not sure if it's my system or from your end, but you can hear me clearly, right?
Yes, I can hear you very clearly, sir.
Okay, speak to your device so that we can hear you clearly.
Okay, is it better now?
Yeah, I think we can manage.
Okay, I said I would say that an issue is a question for legal determination in the case.
Ah, I cannot hear you.
So, using the
Let's listen to another person, pending when your network becomes better. Can we have any other person?
Good morning, sir.
Okay.
So, sir, please, I just want to confirm something that you yeah, I just want to be sure that I got it
Like all the people
correctly,
speaking are having the same
sir.
thing.
So, you told us about challenges.
Good morning, sir. Can you hear me, sir?
Yeah, this is loud and clear. Yeah, go ahead. Hello.
I think he's having network issues, sir.
Okay. So I was beginning to think that it's my system that was having issue, but with the last two speakers, my laptop is still intact. Okay, let's move on then. If we cannot get uh, the issues determined by the members of the group.
Good afternoon, sir.
Good afternoon.
For the issues, these are the things to be considered by the court for determination. An example is, let's say in the case of a bank restricting someone's account.
Okay. Can you
So the
increase your
issue,
volume a bit?
in the case of a bank restricting somebody's account, so what is to be determined is that bank supposed to do that thing, or do they have to? Does the EFCC have to? Does the bank need to give permission before they will restrict the person's bank and things like that? And also in the case of rape, they will look at the issues to be determined at what time did the incident occur? Was there consent? So those are the things that the courts will be looking at, the issues.
Thank you very much. That was a beautiful one. So those are to determine the issue. And then once the issues are determined, the next duty is to apply the law to the fact to determine the legal issue, which automatically leads to the decision in the case. And in case reporting, the judgment, there are two sides to it, which that's why we have the ratio decidendi and the obiter victory. What do you understand by ratio decidendi? Anyone?
The reason behind the
The
decision.
reasoning behind the decision, sir.
PDP and APC? Is that what the person said?
No, sir. The reasoning behind the decision.
Okay, all right. As I've also said that earlier, why obiter dictum will mean what?
Comments made by a judge during the course of deciding a case.
Okay, that's correct. Example, which other examples? Apart from comments?
Remarks made by judges in a case
Remarks,
that doesn't
yes.
have binding effects.
Yes. Which other example?
These are things said in passing while he's making his judgments.
Okay, so we have been giving examples. I want more examples to be sure we know what we're talking about. Opinion, explanation, and so on and so forth, in addition to what you said. All right, so it is the judgment that stipulates all of this. Okay. So, how then do we do case reporting? How to locate a case? So, you as a legal researcher, we need to understand how case law relates to your work and how to use cases as a source of law. That's number one, because that serves as a foundation. And then, like we said, case reporting involves distilling the important element from a case to aid your research. For example, if anybody is to write on bankers and client relationship, the explanation or the issues raised by the scholar who talked about withdrawing, who gave us example of an issue, withdraw money from customers' account, whether they have the rights and all of that. And then if you are tomorrow, you want to do an academic work or paper on that topic uh, of bankers and customer relationship, you know that that aspect of whatever decision of that court on that issue will form part of what you can deploy. There are many cases cover a wide range of issues, so it is important to know and understand how a particular case will aid your research. And if there is a case, there are many issues that can be before the court, which the court will usually determine expressly and must give a decision on. Then the last one here is therefore adopting effective case reporting strategies and processes is a very important part of legal research. So I have it here as part of my presentation that identify a case based on your research on the topic, find the law using case citation through your library or the digital platform. Okay, once you have done that, the next thing is to check the summary. The summary will give you a brief idea because of course the judgment can be up to 300 pages. I remember the day that the judgment that brought Osumole back to power after he was robbed of his little dead took almost a whole day. I could remember that there was a public holiday or something in Benin on that day. Everybody had to be at home, and the judge, yes, read it almost for a whole day. So, if you want to do a legal research, you may not have all the luxury of time to do that, but check the case summary, then jot down important facts, and begin to think in your mind how those facts relate to what you are doing, then outline relevant issues. When you have outlined the relevant issue, summarize the ratio, and then jot down an interesting obita, which can also help in subsequent uh, cases. Okay, so with that, we come to uh, the end of the topic, which is uh, law report. Practically cover the what law report is, the history, the types, features of a law report, how to locate a law report, and so on and so forth. So we'll call it a day here. It may somebody is saying it may look like I'm doing nothing, but in my head, I'm quite busy. Who is disturbing us with these quotes? Okay, all right. Um, I'm going to open the. Is there any question?
Yes, sir.
What?
Yes, sir.
Please go ahead.
So, sir, when we were talking about challenges in case reporting, I there was a point where I faded away. So I just want to confirm something. So when we talk about the challenges, right, there are different kinds of challenges. To be sure that I got it right, you mentioned one, delay in publication. Two, you talked about access at acres, what you said actually. Then I think the last one you mentioned was coverage. Coverage is another challenge. I don't know. Sir, is that what you said?
Coverage. Coverage. That some people will focus on one court and leave the rest. Some it's yours the Supreme Court they report. Meanwhile, there are activities at the Court of Appeal that also to be reported. Okay, so it's a,
Okay, sir. You mentioned four.
is that what?
Sir, you mentioned four. Please, what's the fourth one?
I talked about delay in publication, inconsistency in citation style, access and cost, and then coverage. So, guys, you can start sending your
All right,
attendance.
sir. Thank you, sir.
Yeah, one attendance per device. Okay, so if there are no other questions from you, we call it a day here. And by the grace of God, we meet next time to discuss the remaining part of the part two of this course. Thank you very much for listening and enjoy the rest of your day.